Jury trial in the Circuit Court of Wright County, Missouri, 44th Judicial Circuit. State of Missouri versus Darrell McClanahan. Case number 22 WRCR 00256, 22 WRCR 00553. The Honorable R. Craig Carter presiding. Defendants' closing arguments. Kansas City Attorney Benjamin Arnold. Members of the jury, first I want to thank you for your service. One of our most important rights as citizens is the right to a jury of our peers in most civil and criminal trials. After hearing from various witnesses and examining the exhibits, I urge you to reflect deeply on the evidence presented and the testimony you have heard throughout this trial. The prosecution has presented my client in a less than favorable light, but you will be asked to decide this case as an impartial juror and guide your decision with only the evidence heard in court and the law as explained to you by the judge. As you have heard the past 2 days, this case involves my client being charged with harassment in the first degree based on the title of a video posted on his YouTube channel, Missouri Battle Flag. Best Cock-Sucking Whores in Ozark County, Missouri. The state began by offering the testimony of Melanie Oxley, who explained how she became aware of the video being posted. She testified that she was concerned about her employment as a teacher and self-reported to her school district that it existed shortly after it was posted. You heard from her that she had never even met Mr. McClanahan, but was aware of there being some dispute between her then-husband Joshua Johns, who you heard from multiple witnesses was charged criminally as a result of his conduct at Mr. McClanahan's residence. Next, you heard from Lauren Steele, who was also made aware of this video by someone who had seen it. Similarly to Ms. Oxley, she was also a teacher and soon after self-reported this to the district. She further testified that she had not really known Mr. McClanahan prior to the video but knew of his YouTube channel. Just as the first witness, she was also related to individuals who my client was having issues with. The state also called Tate Steele, who is married to Lauren, and testified that while people had seen the video, he didn't think anybody believed what the title was claiming was true. After hearing from Ms. Oxley and Ms. Steele, you heard the testimony of Deputy Miller, who investigated the incident and interviewed my client about it. You heard how my client admitted to having the YouTube channel and posting the video. You heard how my Mr. McClanahan expressed his anger about what he told the deputy was happening to his family during that time, and his disappointment in how he felt it was being investigated. After hearing from the state's witnesses, you heard from my client's wife, April Miller McClanahan, who went into great detail of the events occurring around the time this video was posted 3 years ago. You heard how there were flyers found depicting her in a sexually explicit manner, and how her husband was convinced his neighbors had something to do with it, but they were unable to determine who was leaving them. You heard how her husband had disagreements with his neighbors and would often argue with them around this time. Mrs. McClanahan testified that her husband posted the video on YouTube out of anger towards men who were related to the women mentioned in the video. Mr. McClanahan then testified further, explaining why he posted the video. At great length, he described what his family was going through with finding flyers around his home, hearing gunshots, explosions, and having disputes with Mr. Steele and Mr. Joshua Johns, who was married to Melanie Oxley at the time. He explained how Mr. Johns was charged criminally after having came to his home trespassing and disturbing the peace. Mr. McClanahan described how he had made multiple reports to law enforcement, but ultimately, they were unable or unwilling to identify who was creating the distributing sexually explicit cartoons drawn depicting his wife, April. He testified that despite this, he believed it was one of his neighbors that was doing this because of the property line dispute. They didn't like us. When asked what his purpose was in posting the video he is being charged with harassment for posting, he said he was doing it, for a lack of better term, revenge. He further testified that he was only posting about the women, to bring attention to the issues he was dealing with his neighbors. When asked whether he intended to cause harm to their reputations or cause them grief, he answered no. Despite living in Ozark County from 2018 until 2021, he had never even met either Ms. Steele or Ms. Oxley prior to the video being posted, and even got one of their names wrong in the title. Mr. McClanahan testified that he chose such a title because it would get their attention. When asked, he didn't actually believe that the claims in the title about the women were true. Rather, it was posted as a hyperbolic statement to, for lack of a better term, retaliate for what he felt was being done to his family by those related to the women mentioned in the video. Lastly, you heard from Deputy Hannaford, who was initially unable to recall his interactions with Mr. McClanahan. Due to this being over 3 years ago, Deputy read a police report detailing a complaint made by my client against his neighbors. He read that Daryl complained about being intimidated by his neighbors, that Ronald Lee Steele was shooting at a target with Mr. McClanahan's face in the crosshairs of a rifle scope, which he then confirmed after following up with Steele. After hearing from all of the witnesses, you must weigh the evidence and follow the law as instructed to you by this court. In order to find the defendant guilty of harassment in the first or second degree, you must find all of the required elements are met beyond a reasonable doubt. Should you fail to find these elements exist, you must render a verdict of not guilty. It is my position that the purpose of causing emotional distress on the victims is lacking. Both of them testified they had not even met him prior to this but were aware of disputes between him and Mr. Steele and Mr. Johns around the time they were posted. My client testified that he posted this video to get the attention of these men, and that he did not post it with the intention of ruining the women's reputations. He actually posted the incorrect name for Lauren, calling her Heather in the title. Furthermore, he testified that he had since deleted the video, despite never being asked to, but because he had moved from the area and wanted to move on. I am confident that you have heard the evidence and will now decide your verdict based on what was heard and the law as instructed. But beyond the legal technicalities, I implore you to consider the human cost of a wrongful conviction. My client's reputation, livelihood, and future hang in the balance. A verdict of guilt would not only be a miscarriage of justice but a devastating blow to an individual who deserves your compassion and fairness. Remember, the burden of proof rests with the prosecution, and they have failed to meet it. My client is innocent until proven guilty, and the evidence presented in this courtroom falls far short of establishing guilt beyond a reasonable doubt. Should you find that the state has failed to meet any of the required elements for the offense of harassment, as instructed by this court, we would ask that you find the defendant, Daryl Leon McClanahan III, not guilty. I ask you to uphold the principles of our justice system, to set aside any biases or preconceptions, and to deliver a verdict based solely on the evidence presented in this trial. Justice demands nothing less. Thank you.